to you. I have several questions that that I've been given in advance, but that doesn't mean that I can't take questions from the floor, or especially follow-up questions if something that I'm saying is unclear. I'm looking at my Zoom right now and I can't see the chat box. I don't know how I get to that function. So I'm going to rely, I think, on Cheryl and others to, stop me until I can figure out. I did the screen share, and that's enough for me for today to have that accomplished. So I'm not asking for too much more. But so anyway, that, just so you know, I got to agree to be, okay, here we go.
I'll watch chat for you, Anne.
Okay, so this is the fact that, let's see if I can actually move it forward. All right. Okay. So the first question, I'm excited, it actually worked. We were advised by our tech guy that it might be smart to add something to our internet policy regarding harassment. Would this be advised? What was the best way to word that? Should it be about the internet and the use of library policy? Board members comment, I think people who use library equipment to harass others should be barred from using library equipment. So would we have to have something like verified accusations of harassment? This has a lot of questions in it. I'm going to cover the first two, but Cheryl, don't let me forget the verified accusations of harassment issue, okay? So I actually approach this in two different policies. I approach it in both the patron behavior policy and the internet use policy. And I've just copied two provisions that I think have to be, that should be in every patron behavior policy. One is that everyone who is in the library should be engaging in proper library activities. So people not engaged in reading, studying, writing, participating in scheduled programs, using library materials. So this is a little bit murkier, because the harassment, if they're not using the materials in the way that they're supposed to be using them, I think this is one of the provisions that you could use. The other one is the harassment policy. And what the problem with harassment is that sometimes it's really in the eye of the beholder. I mean, if you have someone, I might feel intimidated or harassed by someone that, someone sitting next to me might just think is kind of, blows it off. It's not a big deal, right? So you have to really, and the other thing, and I'll get to that in a minute. So harassment, what we do then is we put what we call an objective standard on our harassment provision. So you can see that it's staring, photographing, video recording, audio recording, following, stalking, harassing, arguing with, threatening, talking, or behavior. One, which can reasonably be expected to disturb library users or staff while they're in the library or on library property. I'm going to pause here because there's actually a case where there was a harassment provision in a library policy, but it didn't specify that it had to be on library property, so the court refused to enforce it. So it's really important that you make sure that you limit it to library, in the library or on library property, or that interferes with the library patron's use of the library or the ability of the staff person to do his or her job, or would create or may result in a hostile work environment for library staff, or that violates Michigan law. So it's an objective standard. Is the behavior preventing someone from using the library in a manner? Now, the question that was presented is a slightly different issue, because if someone's using the library computer to harass somebody off-site, I think that's going to be an issue, whether you can really enforce that from a library position. I think you can, but you probably have to have proof to do it. Certainly, if it rises to the level of a crime or an attempted crime, that certainly is something that you can do with your policy. Without a fact-by-fact basis for that. So getting back to, I think that was the only, so then we also have provisions in the internet use policy. I talk about this one because PA 160 or PA 212 prevents you from using the computer in a way that is harmful to minors. So if this patron is doing something that actually impacts minors, the harassment goes to a minor. That's an entirely different issue and can be resolved and should be addressed in your internet use policy. Every policy that you have, like internet use policy, media room policy, should indicate that, and here we have, this is right out of our internet use policy, all internet users must comply with the library's patron behavior policy. So that means that anything that you can't do in the library, you can't also do using a computer. So I think it covers both bases that way. And the other part of the question was, it's a verified accusation. When you get an accusation or someone complains to you, I think it's one of those things where you're really gonna, as a director, I think most of those, especially the serious ones, come to you. You really have to sort of do what I think is a mini investigation. Is it a credible accusation? Maybe. I mean, if it's a patron that complains about everybody, maybe you don't take that as much into consideration as it is to somebody else. And so that's all part of the investigation, whether they violate the library policy. So I don't really know what a verified accusation is. I don't necessarily think that you have to have someone sign a piece of paper. For example, if someone's at the computer and they come to you and say, hey, I think someone's looking at child pornography at the computer next to me, I wouldn't wait till the person gave their name and signed a paper to do that. I would think there's some obligation for you to investigate and enforce your policies aside from that. So I think it's one of those things you really have to take into account. What are the circumstances? Do you think this is a valid complaint? And then, sort of do your own investigation accordingly. So I'm hoping that was the whole answer to that question. Does anyone have any questions on that question? Comments? None. All right. Seeing none, I will move on. Hang on. Question 2. I don't fully understand what was being explained during the Library of Michigan call regarding ANA and OMA and the statement from the Attorney General. We currently have a board member that is going through chemo. She's understandably concerned about being at public meetings, and we'd like to attend virtually. Is this allowed to happen? And if so, what do we need to make that happen? So I think that the Attorney General opinion is a little bit, it's hard to read, and it's I don't think it tells us really anything new, because I think you always had this obligation under the ADA to reasonably accommodate. For example, if you have someone who has a hearing impairment, and wants to come and attend a meeting, there's an obligation in the ADA to make that happen. So I don't think this is really anything new, but it's just being pointed out for the first time. And the reason for that is that prior to December 31st of this year, basically the law allowed board members to attend electronically and didn't really have to state a reason. So we really didn't ever before have to decide whether there's an ADA accommodation that needs to be made. Now, because they're specifically prohibited by the OMA from attending other than military purpose, they can attend electronically, I think, unless they ask for some sort of accommodation under the ADA, and that's what the AG opinion was getting at. So you have to treat this like any other request for an accommodation. This is what we call a Title II accommodation. It's a little different from an accommodation you'd make for an employee, because a Title II accommodation is one that allows people to participate in programs or use the library services. And this would include the ability to attend a public meeting. So the first question you have to ask is, does the person have a disability recognized by the ADA? This is something, again, it's going to be very fact-based, and you're going to have to maybe engage your attorney on. I'm giving you the sort of abbreviated definition right from the statute, but it's a person who has a physical or mental impairment that substantially limits one or more major life activity. This includes people who have a record of such impairment, even if they do not currently have a disability. It also includes individuals who do not have a disability, but are regarded as having a disability. So it covers a lot. The big question that I get is, well, what do you have to do to show that you have a disability? And this is the trickiest part, because as protective as the law is, I think it's unclear under the circumstance what sort of documentation that you would have to have. The public accommodation issues that I've dealt with before have been things that people have an obvious disability. They can't hear, they can't see. I mean, those are those are disabilities that everybody recognizes impair with a major life activity. I think the harder ones are going to be things that are temporary, transitional. They can still be considered disabilities. I think the chemo being immunocompromised is certainly one of those things. And so I think what I'd like to recommend is that I don't think going to be a very common request from you. I have probably dealt with maybe 2 dozen at most ADA questions and library accommodations over the 20 some years I've been doing this. So it's not a thing that comes up every day. Maybe it's just people don't involve me and maybe you guys have a different perspective. But I do think it's something that it's worth reaching out to your attorney to figure out, is this a disability? I've not with libraries, but I've had in other contexts people who, claim to have a disability because they want something different and they don't really have a disability and aren't able to substantiate it. So you'd like to think that anyone who would come to you saying, I'm disabled, I'd like a reasonable accommodation, is being honest about it. Unfortunately, that's not always the case. I would hope your board members would all be honest about it. So that's one thing that's another tricky part, being a director and having to deal with a board member that way. Another reason why you might want your lawyer involved, so then it's not you, it's the lawyers asking the question on your behalf. The other issue is whether the accommodation is reasonable. In this context, I think it's hard because Zoom is so easy to do. We all do it. You did it for 18 months or whatever. I think that's a really simple accommodation. When you get into things that for example, if they want a signer at one of your library programs, and the cost of the signer is your entire budget for library programs for the year, that might not be a reasonable accommodation, and the law will look into those issues. Zoom, pretty easy. I think reasonable accommodation for someone who can't attend virtually, I think that part of the analysis is going to be the easier part. I think it's the is this person disabled under the law, so that you can give them a reasonable accommodation. I will say that every time I've looked at it, the courts are very, very pro accommodation of disabilities. So the likelihood that you'll be able to really, demand doctor's notes and stuff from that is probably not going to be required. Likely it will be just representation by the person that they have a disability. So
and also we did get a question in the chat, and it is about people that are on the board that are out of state, the snowbirds. So unless they have any kind of disability and are asking for accommodation, they cannot attend remotely, correct?
That's correct. And I think when you talk about fact situations, I think that's going to be the trickiest one. Because if you know that you have a board member that has a place in Florida and she goes every year from December to January and all of a sudden has a disability, that's going to be a really, really tricky situation. It may be that she goes to Florida every year from December to January or February because she's got medical conditions that won't allow her to be in the cold. So it's one of those things that's going to be a very factual situation. But you're absolutely correct. Being on vacation or being in a different location is no longer a reason to attend virtually. So it's really, if they're in the military or if they've got a disability, are pretty much the reasons for that.
And so Cindy is saying, so bottom line, is a medical issue considered a disability?
It depends. So for example, there's the federal government puts out sometimes examples of things. They said someone with a broken arm is not typically a disability under the ADA, but it's a medical issue, right? But it's not something that rises to a disability under the ADA. They also say things that are controlled by medication. Even if you're controlled by medication, are still disabilities. I know my son's a type 1 diabetic, so he's controlled by insulin, and so a lot of times he's fine. If you tested his blood, he'd be normal. But he has a disability under the ADA because it needs to be controlled by medication. So they're very, very thorny issues. It's not this person has, has a medical condition. A lot of people have immune disorders. The other tricky thing is a lot of the immunocompromised people have, things that, connective tissue disorders and things like that are really hard to document. So it's a really, really tricky thing. And so again, if there's a doubt, I would have your attorney get in touch with you on that.
There's one more a little comment here that says, can't everyone attend virtually, but board members only participate as an attendee, not a voting board member?
So we've gotten a lot of this. Yes, the public, the limitations on electronic involvement only apply to board members. Yes, a board member can attend virtually as a member of the public would, if you allow that for the members of the public. Now, I would not allow a board member to attend electronically if you don't let the members of the public attend. Okay. You can allow, like, for example, you can allow consultants, like if you needed your lawyer to attend, your lawyer can attend virtually and you don't have to open it up. But when you're talking about a board member attending virtually, you're saying, okay, we allow it because we're treating them like we're treating a member of the public. The trick is that person has to understand that they cannot join the conversation. As soon as they join the conversation, even to comment, that could be an Open Meetings Act violation. Because the OMA covers not only decisions, but it covers deliberations towards those decisions. I think the better thing to do, frankly, unless they want to make a public comment, is to record the meeting and allow them to view the recording. That way you don't risk the Open Meetings Act violation. The only, I think, risk to that is that the recording can then be subject to a FOIA request. But again, it's sort of a tricky position. But I'd be very careful, and they should be under strict instructions to not say a word unless it's in public comment. So, all right, is there any more?
No, we better move.
Yeah, these are very, very layered questions. I was very impressed.
Yes.
So you got to this is the most complicated question. And this is about county library boards. And I was talking to Claire about it too. I think it's very clear there has to be a county library board when you have a contract. I think the statute is very clear. I also think it's very clear that the county board of commissioners is in charge of levying the millage in the way they would any other millage. What's a little grayer is the situation we're getting at here, where do you have to have a library board just to administer the fund? And I think that is something, and I talked to Claire, we're going to have to look a little bit more into that. I think it's one of those things that I don't really want to come out and say anything right now, because I don't want it to cause some county to think they have to disband their library board or create a library board when they don't need to. It's a 19 what is it, it's like early 1900s statute. It's not very well written. It's only like 6 or 7 sections long. It's very sparsely written, and there's not a lot of county libraries have not gotten in a lot of litigation, which is probably a good thing. But because of that, we just don't have a lot to go on. So I would like to look at this a little bit more. One of the things I do throw out there, though, is that I personally do not think that a county board of commissioners is obligated to levy a millage or a full amount of the millage without a contract in place. Because typically, and this is true for cities and townships, unless they're legally obligated to levy the millage, it's within complete discretion of that board to decide to levy it. So I think a lot of communities do have the contracts, just because by contract they can be required to levy it if they agree to do that every year. So that's just one thing to throw out. But I'm going to have to get back to Cheryl on this particular question when I have a little bit more time, and want to flush it out a little bit more with Claire as well before we come down and say, nope, you don't have to have county library boards, or yeah, your county's been in violation of the statute for years for not having one. So that's, I apologize to the person who asked this question, because I do want a little bit more time to respond. I can't see the comments.
Oh, you're good. Thank you very much.
Okay.
Keep going. You're
Okay.
good. Thank you.
Okay. This is a really interesting question. I have another sort of side issue that I do want to address, but can you have a policy about unattended adults in the children's room? Can you ask adults to leave a space intended for teens, etc.? This is a really tricky issue. We've grappled with it over the years. I have a hard time, because if there's library materials in that space, I think it's hard to ban them. Because think about it, if you have a grandpa or a grandma that's visiting your local library to get books out for their kids, you don't want to write a policy that would prevent that. At the same time, we've had people looking at pornography in the children's section. We've had people doing, things in the children's section they shouldn't be doing. So you want to be really careful of that. Can you guys hear my dog? I apologize. She's very loud to me. I hope he's not loud to you. So I gave you an example of one that I have done that I think is sort of sort of gets at the idea here. It basically says that, because do you want an adult not to be in the teen section during school hours? Maybe there's nobody in there during school hours when kids are in session. Remote learning is a little bit different. There may be more homeschool kids now than when I grappled with this issue. So this might be a little bit more tricky now, but I italicized the part that I think should be in the policy that says should limit their visits to the teen zone to the perusal of the collection and selection of materials. So it would allow someone to come in if, for example, if your teen zone has materials they can access in that. I think your internet use policy can address different, if you have dedicated computer terminals, for example, for children, that should be in your internet use policy. So this one, was geared towards a community that really didn't have anybody in their teen section when kids were in school. And so this is the compromise that we came to. It's not that you can't use it. Yes, no, it's you can use it, but here's the limitations for the teen zone. Because you really don't want the creepy man or woman just sitting in the teen zone all day, like talking with teens. I get that, but from a constitutional perspective, you have to be pretty careful with it.
Thanks, Anne. And I want to go back just because we did get a comment after I told you there weren't comments about the previous one. So it's Patty Rockefeller, White Pine District Library. So she says, so even though the millage passed and we do not have a specific contract with the county, that is not considered a contract? ? So that's tricky wording.
And you
go ahead.
Well, but can I just ask, and I know you're going to look into this anyway, Anne, but so what I guess you have to actually, like we do with the other townships, we would have to seek to enter into a contract with the county in order for them to automatically levy the full millage?
Well, here's what I don't want to do. I don't want to say anything. Patty, can I call you after? Because because it's being recorded, I don't want to say anything that I'd prefer to have that. Anyone who wants to talk to me about Patty's, I will talk to anyone about Patty's question privately. So anyone who wants to call me about Patty's question, I will be happy to have a conversation with. I just want to be careful what I say publicly.
Perfect.
I will not charge you for that conversation either. If you're
There is another question related to the one that you just talked about, question 4.
Okay.
It says another facet, adults with disabilities using children's computers. In this.
Adults with disability.
Yeah, so I think what she's saying is, can you have a policy that limits adults, even if they're adults with disabilities that want to use the children's computer?
I think you can limit adults and not have it apply to have an exemption for adults with disabilities. I think you can make adults have used it. I don't think you have to make an exception here. Again, not because you are if you were excluding them entirely from the section, I think we'd have a different issue. You might have to make accommodations if that person has a disability. For example, maybe they can't come during non-school hours, and then maybe that's something you're going to have to accommodate, and we can figure out that accommodation. I have also written a lot of, I've revised a lot of, and I don't mean to sound disrespectful to adults with disabilities, but I've amended a lot of policies that deal with unattended children, to deal with unattended children and vulnerable adults, because there's a lot of libraries where I understand people with disabilities, the parents, I think they get just, they need a break. So they drop their disabled adult at the library for, several hours. And I think there's provisions that the library should have in place to deal with that, in case, making sure that that person has the ability to, because people with different disabilities are on a wide spectrum, and there may be people with disabilities that need no intervention on behalf of the library. There are some people with disabilities that really shouldn't be there on their own, and you want to make sure that you have a policy in place to address it if they in fact drop off a vulnerable adult who does not have the capacity to take care of themselves during that time. So that's just, it's not really the question asked, but I do want to point that out because I see that as an increasing issue that libraries are facing.
Thank you. Let's move to question 5.
No, that's me. Well, just waiting for someone else to move the thing, I guess. Uh-oh. What happened?
Your screen sharing all of a sudden stopped screen sharing. So
okay, I don't know what I did. Hang on one second. Are we back?
let's see. We have a no, because the wrong tab was up. We have your Zoom tab instead of you're not sharing your presentation.
Okay. I'm gonna just tell you, I have no idea what's happening with my presentation. When I click on it, and I say from the beginning, it runs through my whole presentation and stops. I've never seen anything like it.
Would you rather me throw up the questions? I've got them in a Word document. What would you like?
Yeah, I can, let me do this. I apologize. I think most of it, I wanted to share the first ones particularly because, let's see, what question were we on?
I want to say 4. Hold on a second. Let me pull it up. Let's see. No, 4 was about the unattended adults in the children's
room. So are we okay with that? And I apologize. I've never seen this happen to my thing before. It's like it's,
let me see if I can screen share mine.
What is question 5? About the friends organizing?
Hold on a second. I'm sorry. I'm multitasking here. Do you see my screen now?
Okay.
Can you see mine?
Yeah.
Okay. Seville Township Library, should we be looking into setting up our own EIN? Is it worth the hassle? Are there any benefits to getting our own? Or do we need to continue using the townships because we're a PA 164?
So I looked into this, and the EIN number, really the big issue comes down to do you have your own employees? If you have your own employees, if they're library employees, then you certainly need your EIN number. What I haven't been able to track down is whether there's any negative aspects of having an EIN number, even if you don't need one. But I certainly, if you have your own employees, you need to do that. PA 164, I caution this, and I call this opening the can of worms. So you guys might want to cover your ears and not listen to this. But sometimes with PA 164s, and this brings up the issue, there's an actual issue of whether they're library employees or township employees. So for example, if you think they're library employees, but they're getting their health insurance and retirement benefits from the township, they might actually be township employees. So sometimes when you talk about EIN numbers, this is where the can of worms gets opened, and it's not a bad thing, because I think resolving that issue is something that I think is in the long-term best interest of the library anyway, but that opens that up.
What's the test, Anne? Is it who runs the payroll? Is that the test?
The test is who's the common law employer. So who hires, fires, has the ability to discipline, does the employment evaluations. So here's where it gets tricky. If the library board does all that, and the library directors, they think the library director is a library employee, but you're getting your benefits from the township, one of 2 things is possible. One is that the township's benefits plan have the township library as a separate employer, but a lot of times we see that they're actually listed as township employees on the benefits, and the risk is that you have a situation in which for example, I tell people, like, I work at Foster Swift. I think it's common, understanding that if you don't work at Foster Swift, you can't be on the Foster Swift healthcare plan, right? Because you're not an employee of Foster Swift. The same is true in the library and township library context. If you're a library employee, you can't be typically on the township's benefits plan. And a lot of the people who run the plans administratively, the healthcare companies and those other things, don't understand that a PA 164 township library is actually a separate legal entity. So that's where it gets a little tricky. So again, a little off topic with the EIN, but I just, I want to point that out because that's one of the issues that will come up when you talk about getting your own EIN, especially if you start, are they your, for the purpose of employment issues, because that will raise that issue that will need to be resolved.
Thank you. Shall we move to number 6, Bel Air Public Library? We are currently working with our Friends group to reorganize. At this time, they are simply a volunteer group and the library is acting as the fiduciary. This group is not a 501c3, 3C, 3C, anyways, and had no nonprofit status paperwork. They were simply putting funds earned for their events into a checking account and writing library checks for expenses as they came up. Legally, what does this group need to do to operate as an official nonprofit, and how do they go about doing this?
Well, the simple answer to the question is that they should organize as a nonprofit under Michigan law. They have to incorporate as a nonprofit corporation. That's pretty easy to do under Michigan law. A lot of times you can get a local attorney maybe to do that pro bono for a group. That's something that if someone's pretty savvy, they could probably do it on their own. It's an incorporation provision under Michigan law. The thing that's a little bit more complex is the 501c3 status, because not every Michigan nonprofit corporation is a 501c3. That's a federal tax exemption. And that's a process where you have to apply and get your 501c3 status. So I don't think I'm not a corporate attorney or a tax attorney. So I don't want to tell you that whether that your friends do or don't need a 501c3. I think it's certainly advantageous for libraries, because usually why libraries want to deal with the friends is that some libraries are 501c3s, not all libraries, and some of the grants that you're applying for can only be applied for by a 501c3. So I think there's definitely reasons why you would want to encourage your friends to become a 501c3. So that's the number one reason. I do want to kind of point out too that I don't know if I want to delve too deep into what you mean by you're acting as a fiduciary, but the Friends should be a separate entity from the library. You should not be handling the Friends money. You should not be putting it into the library fund. It should be very separate, with the caveat that I recommend that libraries and their Friends group get into a memorandum of understanding. That's a contract that explains what the relative responsibilities between the two groups are. For example, if you let them have space in the library, if you give them books, and then you want to make sure they're contractually obligated to give you the money back. We've had a lot of Friends groups that have gotten crosswise with the library. And so one group, for example, took all the book money that they raised and donated it to another local literacy group. And they're allowed to do that under their nonprofit corporation status. So again, I'm going to do a library series, again, a webinar series on topics. And I think I'm going to touch this one again. I do one calling Staying Friends with the Friends, because sometimes it's hard to stay friends with the friends if you get in get in situations with them. But there should be very separate entities and start acting that way. And the memorandum of understanding can really outline that relationship.
Okay, this was from us, and we do have a memorandum of understanding. The problem is that the Friends really basically disbanded.
Okay.
And so what we've done is we're calling them our Friends group. They are simply volunteers. There is a steering committee, but the problem was that the treasurer was not comfortable with the fact that she was taking in money and writing checks without any real, I mean, she was the only person writing the checks. And so when I say we act as a fiduciary, we really aren't acting as a fiduciary on behalf of the Friends. The Friends are our volunteer group that do fundraising activities. And when that fundraising comes in, it goes right into our accounts as donations or fundraising. So in that respect, we were acting as a fiduciary only because we no longer were writing them checks for money that we were taking in for the used book sales, for example. So now when people buy books from a used book sale, it's library money. It's the library's used book sale. The Friends group is simply volunteers.
So in that case, I would take the position that you don't have a Friends group, that they're.
That's kind of how I feel too, but we don't want to
They're
tell
actually
them.
library volunteers.
Yep.
Um,
Yep.
I would never recommend without some sort of memorandum of understanding that you write checks to the Friends.
Right.
Because that's where so let's take a book sale. There's always a question of fact is whose money is that? Is it the Friends money or is it the library's money?
Right.
If it's the Friends money, then the library employees should really not be involved with that.
Right.
Unless you have a memorandum of understanding that by contract, because then you're basically donating public time for private nonprofit corporations. Because you have to treat the Friends, unfortunately, without the memorandum of understanding, you sort of have to treat them like you would any other nonprofit. So would you, if a Girl Scouts are selling cookies, are you taking money for the Girl Scouts and writing them checks for their cookies? You would never do that, right? So you have to really put that mindset in when you're talking about your Friends.
Okay.
If they have absolutely no corporate status, I would not donate books to them or give them anything until they get that corporate status. They can volunteer for you.
Right.
And then, but all that money should go into the library coffers then. It's no longer Friends money, that's library money.
And that's what we've done.
Right.
But but we were very concerned prior to that because they were responsible for the book sale room as volunteers, but then we were writing them a check every month to put into their checking account. It was too much gray area. Our auditor was concerned.
Yep.
And so we met with the Friends, and basically you're right. We don't want to tell them they're disbanded, but they know they are.
Yeah.
There are no officers anymore. They're just committees that we go to when we need help with certain things.
Yep.
But they want to be called the Friends. And I don't think there's a problem with us calling them their Friends, as long as people know they're not an official group.
That's right.
Okay, good. Then we're okay.
Yeah.
Thanks.
Great.
Yeah,
Let's move to number 7. Actually, we have 2 in a row from Betsy Valley. The first one is, can we get a template about the revised video camera surveillance amendment?
I'm really mad because I spent some time yesterday. And I'm going to try this again.
Oh, do you want me to stop sharing mine and you're going to share?
Yeah, let me see if I can. Let me see if I can try again. No, I have no idea what's happening. Okay, so the answer to your question is that you need to revise your confidentiality policy. That if it's the one like we do, I basically redrafted our confidentiality policy. Because there's so many changes to the Library Privacy Act that we really need to I made a complete amendment. And so some of the things that you need in your confidentiality policy are new definitions. For example, crime, law enforcement officer. The big key is about the video surveillance is that you have to make sure that the video surveillance images made solely for security purposes that do not include images of any activity or other document or record that identifies a person as having requested or lawfully obtained specific services, materials, or information resource from the library is excluded from your definition of a public record. So this was I think the biggest change with that is one, I took the position that your video surveillance was library records under the Library Privacy Act. So what does that mean? That anytime the police came, they would need a search warrant for you or some other court order in order for you to even show them, not just provide a copy, but even show them a copy of the videotape. One of the biggest things this did is it took it out with a little bit of a caveat, and that's the caveat that needs to be in your policy and needs to be changed. So I've looked at a lot of video surveillance over the years. Sometimes the images are so grainy, like if someone's holding a book, you could never read what the title is. So if that's something that you could give to the police or show without obtaining a court order. If you have outside videotape and you see and capture someone stealing a bike, that bike is, that surveillance would not likely be something that would have to be protected. The only downside to this is that when you got a FOIA request for it, most of the time it's when the police want to help you solve a crime. So you want to be able to show them this without getting a court order. And I think that is wonderful. The only other thing is that it does open these surveillance up to FOIA requests. So you really have to carefully look at the thing. And sometimes you'll have to make redactions to the video. For example, if you've got someone who's got like walking through with a book and the title's in like 36 font, and you can see it, you might have to blur the title out before you give that to someone pursuant to a FOIA. If you're inside a meeting room, if your cameras are inside a meeting room and you're at a library program, I think the videotaping of a library program probably is something that needs to be protected. So again, there's some nuances to that. It's not yes, video surveillance can be given out. No, it's a little bit of a gray area. You can actually have to look at the videotape to see what's on there.
And we have a little comment here. So what if your video surveillance is through the city and is accessible off-site to public safety? Have you ever heard that one?
Yes. So there's an issue of whether. So this is hard.
We could probably save that one for another day because
that's gonna be very fact-based, because it's gonna be one, is it your record or is it the city's record? That's a huge issue. And secondly, whether we need to stop that practice because of the library privacy issues.
Right. Okay. Well, let's move on, because we can circle back to the chat questions. I see that there's several coming in that are new questions. And so we have already existing questions. Let's just see if we can get some more of these done. These hotspots, this Khajiit, they utilize filters. On the administrative portal, we can see the patrons' traffic or visited sites during their checkout. I know that any illegal activity is prohibited and will be stated in the signed agreement they must read and sign. However, if we were to see that they were conducting illegal activities such as cyber stalking or accessing child pornography, is it our duty to report this to the police? What is the protocol concerning patron library privacy for this? Does their right to privacy override the fact that they committed a crime? So these are for the hotspots that are circulating.
So couple things, a lot to unpack in this question. Kind of approach it systematically. Okay. As far as I know, there's no legal duty to report. Okay. I've looked at this before and I haven't seen anything. So there's no legal duty, but often there's a moral obligation. For example, if you think there's children are being exploited through child pornography, that's typically one where the library will say we're gonna report it. I didn't mention this before, but there's another change to the Library Privacy Act that says that the Library Privacy Act does not prohibit an employee or agent from providing a sworn statement or testimony to law enforcement based solely on their personal knowledge. So one of the things where this can come into play, one of the things that really, it was like a chicken and the egg problem before, because you couldn't even tell somebody about, how do you report it to the police when they have to get a search warrant for you to tell them something? So at least now, I think, and I would consult your attorney, particularly if this is your situation, I think there's ways you could tell, look, I'm not going to give you the name and I'm not going to give you the websites, but I from my personal knowledge, I can tell you that there's improper activity on this hotspot. Those are the types of things I think that I feel comfortable advising clients that they can do now, where before it would be, this might violate the Library Privacy Act. But actually giving over, for example, the hotspots, I'm not sure too. I don't know how likely this would be, because what I want to tell you about I'm not an expert in child pornography. I don't have a ton of experience, but I've talked to law enforcement, and when this has come up in a library, and you can't, and I know there's one task force that tried to Google and do everything searches to find child pornography, and you can't. It's like a dark web type of thing. You can't just stumble really across child pornography. Most of it is file sharing, and you're not going to see that on a hotspot. So probably the likelihood that you're going to see something through internet searches that's going to be problematic from your perspective is probably pretty slim. The way people get caught with child pornography in libraries is when they're seen viewing the images. So in cyber stalking, I think more likely what's going to happen is that someone's going to complain about somebody doing something, and you're going to get a visit from the police, and then you're going to go in and see that they, some sort of connection maybe. I don't know but if you see something, I think you consult your lawyer. Likely you can explain to the police that you see something, but before you actually give over the documents, the websites, I don't know enough about the device to know if you have like a printout of the things, they'd likely have to have a court order, but at least if you give them that sworn testimony, that they'll have a basis to get that court order.
Well, and Anne, I will add here, because I applied for the Emergency Connectivity Fund for 25 of our member libraries, and many of them are getting these hotspots because of that, and circulating devices as well. And the CIPA, the Children's Internet Protection Act, does not apply to the Wi-Fi hotspots, as it turns out. It's because they're circulating to the public, and they're being used with presumably a privately owned device. What the CIPA applies to for this particular program is the devices themselves. So the iPads and the laptops and the Chromebooks have to be filtered. And I think most of us know that are participating in this program. So this was an interesting question about the actual hotspot. And so the program itself does not require us to filter them, but these Khajiit hotspots come already with the filter that you cannot really take off. So
are they filtered? Are they filtered then?
The Khajiit hotspots are filtered, yes. And they can see what people are doing. So it's kind of a matter of, they have the information, do they have to use it? So the answer, I think you're saying, is not necessarily.
Well, and I do think that although CIPA may not apply, I think PA 212 does, because PA 212 says that the library offers the use of an internet or computer. And keep in mind, this is year 2000. We didn't have hotspots back then. So, but it says use of a computer program, computer network, or computer system to the public. It restricts access to minors by providing the use of the internet. So I think it's computer program, computer network, or computer system. I would question whether we would call the hotspots part of your computer network. I think you're certainly offering internet access to the public, and that way I think that if they're filtered, that's fine. But I think that they should be filtered in that way because of that, even if CIPA doesn't require it.
All right, can we move to number 9, which is about meeting rooms, study and meeting room policies? Are there any legal restrictions on for-profit use of library meeting spaces? Our current policy formally states that meeting spaces may not be used for-profit business activities. That seemed like a reasonable stipulation when we drafted the policy, but now I'm feeling like this is perhaps arbitrary and unnecessary. It would be helpful to determine if there's any legal precedent or requirement for such a rule before we proceed with revamping our policies.
Well, there's no legal requirement. I think from a legal perspective, the less restrictions you put or differentiation between groups, the less risky it is. The courts look at the way you categorize different groups from a different, depending on what the group is. Okay, so for example, obviously, if you say men can use the room and women can't, I mean, that's a you're restricting access based on sex. That's a high standard to have to overcome and likely will be unconstitutional. The courts are less concerned about like corporate status. That's a less, I guess is whether it's reasonable or not reasonable would be the standard about whether that access or that differentiation can be made. I know that a lot of libraries do this because, and then they may allow access but charge differently. I think that it's, and I also, for profit, it also concerns me a little bit because, for example, what if a company comes in, wants to use your library, to do a seminar? It's a free seminar, it's educational, but if the end goal is for you to get their business, is that a for-profit or is that an educational seminar? And I think it puts a little bit of, concern for the library that way. I will say, as long as I've been doing this, nobody's challenged that. I think people don't. I think that one of the things that I see that has been challenged, and I think libraries have really upheld, is requiring payment or entrance payment for the use and those types of things. So my question to you would be, is this a problem for your library? Do you have your meeting rooms that are so used that you need to really regulate them? If your space is being used unused, and for-profit businesses want to come in and give an educational seminar, that's going to be a policy decision for the library, but no specific legal issue, legal that requires you to have it that way.
Excellent. Let's move to number 10. It's Luther Area Public Library is one of 3 libraries that receive funds from, guess what? A countywide millage. I think this is associated with that other county millage. Let's keep reading. The others include Chase, Pathfinder, and Baldwin. Foster Swift has helped us getting everything set up a few years ago. We have a Lake County Library Board with the only role of distribution of money from the millage. I have volunteered to be part of the Lake County Library Board since one of our previous directors is resigning from the board. Next year, we will be having another millage vote. As a soon-to-be new member of the Lake County Library Board, what do I need to know?
I think the question posed is not the question that I would ask, and this might be something that I'll have to talk to the director about, but I'm not sure whether that's a compatible office, because you can't, there's a Incompatible Offices Act that prevent you from holding 2 offices. And I'm assuming that the director is asking this and not a board member. If it was a board member, it would be clearly an incompatible office, because then you're basically wearing 2 hats. And so this is one of those things that you may want to talk to your lawyer about, whether this is an incompatible office or not, before you go any further about what your responsibilities are.
Good point. Okay, well, it looks like we're on number 11, and then I can scan the chat to see for other questions. But number 11 is, we are currently working on a public comment policy and wondered if we were able to require that people state their name and address when they step up to address the board.
Yes, as long as it's in a written policy. That was an easy one. I want to point out, though, that I think that where people get confused is that you cannot require someone to give their name, address, or identify themselves to attend a meeting. So this came up a lot during Zoom, because at first, to prevent Zoom bombs, a lot of libraries were requiring you to sign in. And I said, no, don't do that, because Open Meetings Act says you can't put requirements on attending the meeting. So if someone wants to come to your meeting, sit in the back corner and listen, you cannot ask them their name. And I do point this out for smaller libraries and smaller municipalities, because I think I've been in so many meetings where I'm like, oh, stop being so friendly, because someone will walk in that they don't recognize, and the library board will say, oh, hi, who are you? What are you here for? And it's the friendly thing to do, but it's not really technically the legal thing to do. They can volunteer that, but I've had clients that have asked me to attend a meeting and didn't really necessarily want people to know that I was there on their behalf, and I would have had to plead the fifth if someone had asked me. So I think it's just better not to ask.
Great. Okay, so looks like I've got a question from the chat. Our township contracts not been honored by the townships for many moons. In your opinion, does it make more sense to approach them with the choice to discontinue service or enter into a new contract? They are only giving us penal fines and most do not equal 3/10 of a mil.
So I'm assuming that you're a library and the townships are like not part of your service area. They're a contracting service. There's no requirement to provide service to a neighboring community. You know, if you're under a current contract, you obviously have to look to see whether, you know, with any contract, you know, can you break the contract? Yes. Can you be in breach of the contract if you break the contract? Yes. So you want to be careful that you're not breaching the contract, or if you're breaching it, you understand what the ramifications are. But a lot of times libraries, you know, give them the required notice. There's a lot of times required notice under a service contract and tell them they're not going to, and then you can offer to continue it. You know, with most communities, most libraries, the bargaining power is in the hands of the library in these situations, because if you can afford, the question is, can you afford not to serve them? And if the answer to that is yes, you know, but if it's a huge part of your budget and you need their service, your bargaining power goes way down. So that's sort of the position that's why it's not really a yes, no question. It's, can you live with them? Can you live without them? And then if so, I mean,
It's the latter. In this situation, it's the latter. They really need their input with the money. So is there?
Yeah, that's a really tricky issue, because if you're going to go to them and say, you need to pay us all this more to give them service, they can walk away. And then you're left without the money. So it's really a negotiation issue. A lot of times what we do is we really prepare for a meeting and sit down and explain the facts. You've got this many people that use the library. Our residents pay, you know, X dollars per capita. We get like half as much from you guys. Would you be willing to put a millage in place? You know, we really want to make this work, but we need to make it, you know, fiscally responsible for our own taxpayers. So again,
is it legal for them to just be paying the penal fines and not the equivalent of 3/10 of a mil?
yes.
Ooh.
Yeah, it's legal. Let's see. I'm scrolling. Sorry, I'm scrolling through these. Somebody wants a template about.
Now, there's an issue about whether you'll qualify for state aid. That's a clear question.
Right. Financially, they have to meet the 3/10 of a mil for state aid.
I think the library as a whole, I think that's the position that the Library of Michigan takes. Is that right, Cheryl?
Yes,
So
and then sometimes they parse out the parts that don't, so that they can make the 3/10 with the most communities.
But that's what I would maybe talk to Claire about, because that might be a bargaining chip for you. For example, if your situation is that their lack of payment now puts you in jeopardy of state aid, that might be a reason. So that would be the one issue that I'm just not as familiar as the Library of Michigan is with the way that they calculate the state aid and the populations, but I know that's an issue that I would explore.
Okay, well, it looks like we have a couple more minutes and I see another question if you're willing.
Absolutely.
The library board writes the director job description. Does the director write the other personnel job descriptions? And if so, what can I point to that allows the non-director staff job descriptions to be removed from the library policy so that they can be changed without board approval, if that's allowed?
So typically the board is in control of the job descriptions. The only caveat to that is whether they have delegated that responsibility to the director. If they have, then the director can write the job descriptions. I will say that though, I still believe that's always in the control of the board. So if they don't like what the director's doing, they can take that responsibility back.
Where does the distinction between the board does not supervise directly the staff come into play with what you just said?
Because when you're setting a job description, you're talking about what's the, you know, just like the board would be responsible for determining like the needs of the library and what type of needs that the library have. And to me, the job description falls into that and is not the date. the day-to-day management of whether the person's complying with the job description, I agree, falls into the day-to-day management, but the job description itself is more like a policy decision.
Great. Okay, let's see. Thanks, a bunch of thanks. I think we're at the top of the hour, Anne. So what we said, and actually let me just take a moment to say that Anne and I spoke about our cooperative possibly offering out to every member library 1 hour of Anne Seurynck's time for legal questions. And in order to make that so, each of the members would need to have an agreement signed and take to their board that would be an agreement with Anne's law firm. Is that correct, Anne?
Yeah, I just want to point out, because a lot of you guys are clients and you signed a retention letter with us. If you already have a retention letter with us, you don't need to sign something different. But I can't give legal advice without entering into an attorney-client privilege relationship. What I want to be really careful to mention is that does not obligate you in any way to have us as your lawyer beyond what, the library is, beyond, you're not obligated to anything other than if you call us and want us to help you. So if there's no, I think, retainer or, commitment. And I think that's what I just want to make really clear, but I do need to establish the attorney-client privilege relationship so that I can provide the legal advice and be covered, by, our firm's policies. And one of the things too with our, because I think someone asked about the template for the confidentiality policy. What we do at the firm is that we develop policies and we update policies, and I never like to charge the first library that comes through the door to research and review a policy. I won't even tell you how much I spent on our FOIA policies, but it was over $10,000, and I'm not going to charge a library $10,000 for that policy and then have them absorb the cost. So what we do, and it's in the retention letters, that we have flat fees. So for your typical standard policy, I charge 1 hour worth of time, which is what you have been given through the co-op. So for example, if you wanted our standard confidentiality policy, you could ask for that. The co-op would pay for it. I typically charge by the hour for changes to the policy. But if you're using the 1 hour with the co-op, I'm willing to bend that rule a little bit. And if you want some changes to it, I wouldn't charge for that, unless it was like hours and hours of time and lots of research. That's my caveat to my caveat. But if you just wanted me to go through and make some changes, I'd be happy to do that.
Oh, we're so grateful, Anne. So members, think about whether you would want to take this agreement back to your board and have a retention letter with Anne Seurynck. And in the meantime, Anne and I will get the draft of the letter going, and we will have this recording, and we'll follow up with the county library issue, Anne. And how would that work? I'm getting questions about how we would do that. Shall we just set up a phone call or emails or?
Well, I think, so if you're, how about this for now, until I get it straightened out? If you are does everybody have a county library question, or just?
I think there's just 2 of them. I think
2 of them.
And actually, I think it's White Pine District Library is down in Montcalm.
So how about this? How about I just tell Patty you can call me and I will give you my response in private for no charge. How's that? And then if there's somebody else, then I will talk to them about that too.
Okay, that's.
I was one of them.
Oh, there's Amy. Your question was about, Anne was saying that you might have an issue with your role as library director and then also being on the county board. So that was that was the issue that she was talking about.
Everything has all been set up. I'm just the new member I'm the director of the Luther Library, and I've volunteered to be on the board of the Lake County library board. And my question was more just a general understanding of what of this whole thing means in regards to, I mean, I understand that we have a county board and it only meets in order to, for the distribution of the millage money. But I just wanted to have a little bit more clarification as what it all,
Okay.
what it meant.
And Anne, I think we can include that in the 1 hour for Amy, once we get to that point.
Okay. Yeah,
anyways.
Amy, I want to look at I'll look at, because I have a kind of a concern about your situation, and I'll look into that before we even talk.
Okay.
And then we can set up a time to talk.
Okay.
Yay. And thank you again, Anne Seurynck, for your time. It's been invaluable. We appreciate today's hour, and we've gone over. So
Cheryl?
Anything I can do to help. I love working with libraries, so I really appreciate it's the greatest group of clients, so I appreciate that. Don't show this recording to my city clients though, because
no city clients.
But
Cheryl, can you stay on for a minute so I can talk to you
Sure.
afterwards?
Sure. Okay, so we're going to officially end this session. And again, with appreciation to Anne Seurynck, and
well, thanks for the opportunity, everybody. Thanks, Cheryl. Bye, everybody. Have a good day.
Stop recording. I don't know how to stop recording.